Code of Professional Responsibility, Full. Chapter 1. The Lawyer and Society. Canon 1. A lawyer shall uphold the Constitution, obey the laws of the land, and promote respect for law of and legal processes. Rule 1.01. A lawyer shall not engage in unlawful, dishonest, immoral, or deceitful conduct. 1.02. A lawyer shall not counsel or abet activities aimed at defiance of the law or at lessening confidence in the legal system. 1.03. A lawyer shall not, for any corrupt motive or interest, encourage any suit or proceeding or delay any man's cause. 1.04. A lawyer shall encourage his clients to avoid and or settle a controversy if it will admit of a fair settlement. Canon 2. A lawyer shall make his legal services available in an efficient and convenient manner compatible with the independence, integrity, and effectiveness of the profession. Rule 2.01. A lawyer shall not reject, except for valid reasons, the cause of the defenseless or the oppressed. 2.02. In such cases, even if the lawyer does not accept the case, he shall not refuse to render legal advice to the person concerned if only to the extent necessary to safeguard the latter's rights. 2.03. A lawyer shall not do or permit to be done any act designed primarily to solicit legal business. 2.04. A lawyer shall not charge rates lower than those customarily prescribed unless the circumstances so warrant. Canon 3. A lawyer in making known his legal services shall use only true, honest, fair, dignified, and objective information or statement of facts. 3.01. A lawyer shall not use or permit the use of any false, fraudulent, misleading, deceptive, undignified, self-laudatory, or unfair statement or claim regarding his qualifications or legal services. 3.02. In the choice of a firm name, no false, misleading, or assumed name shall be used. The continued use of the name of a deceased partner is permissible, provided that the firm indicates in all its communications that said partner is deceased. 3.03. Where a partner accepts public office, he shall withdraw from the firm his name and be dropped from the firm name unless the law allows him to practice law currently. 3.04. A lawyer shall not pay or give anything of value to representatives of the mass media in anticipation of or in return for publicity to attract legal business. Canon 4. A lawyer shall participate in the development of the legal system by initiating or supporting efforts in law reform and in the improvement of the administration of justice. Canon 5. A lawyer shall keep abreast of legal developments, participate in continuing legal education programs, support efforts to achieve high standards in law schools, as well as in the practical training of law students and assist in disseminating the law and jurisprudence. Canon 6. These canons shall apply to lawyers in government services in the discharge of their tasks. Rule 6.01. The primary duty of a lawyer engaged in public prosecution is not to convict, but to see that justice is done. The suppression of facts or the concealment of witnesses capable of establishing the innocence of the accused is highly reprehensible and is cause for disciplinary action. 6.02. A lawyer in the government service shall not use his public position to promote or advance his private interests, nor allow the latter to interfere with his public duties. 6.03. A lawyer shall not, after leaving government service, accept engagement or employment in connection with any matter in which he had intervened while in said service. Chapter 2. The Lawyer and the Legal Profession. Canon 7. A lawyer shall at all times uphold the integrity and dignity of the legal profession and support the activities of the integrated bar. Rule 7.01. A lawyer shall be answerable for knowingly making a false statement or suppressing a material fact in connection with his application for admission to the bar. 7.02. A lawyer shall not support the application for admission to the bar of any person known by him to be unqualified in respect to character, education, or other relevant attribute. 7.03. A lawyer shall not engage in conduct that adversely reflects on his fitness to practice law, nor shall he, whether in public or private life, behave in a scandalous manner to the discredit of the legal profession. Canon 8. A lawyer shall conduct himself with courtesy, fairness, and candor towards his professional colleagues and shall avoid harassing tactics against opposing counsel. Rule 8.01. A lawyer shall not, in his professional dealings, use language which is abusive, offensive, or otherwise improper. 8.02. A lawyer shall not, directly or indirectly, encroach upon the professional employment of another lawyer. However, it is the right of any lawyer, without fear or favor, to give proper advice and assistance to those seeking relief against unfaithful or neglectful counsel. Canon 9. A lawyer shall not, directly or indirectly, assist in the unauthorized practice of law. Rule 9.01. A lawyer shall not delegate to any unqualified person the performance of any task which by law may only be performed by a member of the bar in good standing. 9.02. A lawyer shall not divide or stipulate to divide a fee for legal services with persons not licensed to practice law except a. Where there is a existing agreement with a partner or associate that, upon the latter's death, money shall be paid over a reasonable period of time to his estate or to persons specified in the agreement, or b. Where a lawyer undertakes to complete unfinished legal business of a deceased lawyer, or c. Where a lawyer or law firm includes non-lawyer employees in a retirement plan, even if the plan is based in whole or in part on a profit-sharing agreement. Chapter 3. The Lawyer and the Courts. Canon 10. A lawyer owes candor, fairness, and good faith to the court. Rule 10.01. A lawyer shall not do any falsehood or consent to the doing of any in court, nor shall be misled, nor shall he mislead or allow the court to be misled by any artifice. 10.02. A lawyer shall not knowingly misquote or misrepresent the contents of a paper, the language or the argument of opposing counsel, or the text of a decision or authority, or knowingly cite as law a provision already rendered inoperative by repeal or amendment, or assert as a fact that which has not been proved. 10.03. A lawyer shall observe the rules of procedure and shall not misuse them to defeat the ends of justice. Canon 11. A lawyer shall observe and maintain the respect due to the courts and to judicial officers and should insist on similar conduct by others. Rule 11.01. A lawyer shall appear in court properly attired. 11.02. A lawyer shall punctually appear at court hearings. 11.03. A lawyer shall abstain from scandalous, offensive, or menacing language or behavior before the courts. 11.04. A lawyer shall not attribute to a judge motives not supported by the record or have no materiality to the case. 11.05. A lawyer shall submit grievances against a judge to the proper authorities only. Canon 12. A lawyer shall exert every effort and consider it his duty to assist in the speedy and efficient administration of justice. Rule 12.01. A lawyer shall not appear for trial unless he has adequately prepared himself on the law and the facts of his case, the evidence he will adduce, and the order of its proference. He should also be ready with the original documents for comparison with the copies. 12.02. A lawyer shall not file multiple actions arising from the same cause. 12.03. A lawyer shall not, after obtaining extensions of time to file pleadings, memoranda, or briefs, let the period lapse without submitting the same or offering an explanation for his failure to do so. 12.04. A lawyer shall not unduly delay a case, impede the execution of a judgment, or misuse court processes. 12.05. A lawyer shall refrain from talking to his witness during a break or recess in the trial while the witness is still under examination. 12.06. A lawyer shall not knowingly assist a witness to misrepresent himself or to impersonate another. 12.07. A lawyer shall not abuse, browbeat, or harass a witness or needlessly inconvenience him. 12.08. A lawyer shall avoid testifying in behalf of his client except a. On formal matters such as the mailing, authentication, or custody of an instrument and the like, or b. On substantial matters in cases where his testimony is essential to the ends of justice, in which event he must, during his testimony, entrust the trial of the case to another counsel. Canon 13. A lawyer shall rely upon the merits of his cause and refrain from any impropriety which tends to influence or gives the appearance of influencing the court. Rule 13.01. A lawyer shall not extend extraordinary attention or hospitality to nor seek opportunity for cultivating familiarity with judges. 13.02. A lawyer shall not make public statements in the media regarding a pending case tending to arouse public opinion for or against a party. 13.03. A lawyer shall not brook or invite interference by another branch or agency of the government in the normal course of judicial proceedings. Chapter 4. The law and the client. Canon 13. A lawyer shall not refuse his services to the needy. Rule 14.01. A lawyer shall not decline to represent a person solely on account of the latter's race, sex, creed, or status of life, or because of his own opinion regarding the guilt of said person. 14.02. A lawyer shall not decline, except for serious and sufficient cause, an appointment as counsel de officio or as amicus curiae, or a request from the Integrated Bar of the Philippines or any of its chapters for rendition of free legal aid. 14.03. A lawyer may not refuse to accept representation of an indigent client unless a. He is not in a position to carry out the work effectively or competently, b. He labors under a conflict of interest between him and the prospective client or between a present client and the prospective client. 14.04. A lawyer who accepts the cause of a person unable to pay his professional fees shall observe the same standard of conduct governing his relations with paying clients. Canon 15. A lawyer shall observe candor, fairness, and loyalty in all his dealings and transactions with his clients. 15.01. A lawyer, in conferring with a prospective client, shall ascertain as soon as practicable whether the matter would involve a conflict with another client or his own interest, and if so, shall forthwith inform the prospective client. 15.02. A lawyer shall be bound by the rule on privileged communication in respect of matters disclosed to him by a prospective client. 15.03. A lawyer shall not represent conflicting interests except by written consent of all concerned given after a full disclosure of the facts. 15.04. A lawyer may, with the written consent of all concerned, act as mediator, conciliator, or arbitrator in settling disputes. 15.05. A lawyer, when advising his client, shall give a candid and honest opinion on the merits and probable results of the client's case, neither overstating nor understating the prospects of the case. 15.06. A lawyer shall not state or imply that he is able to influence any public official, tribunal, or legislative body. 15.07. A lawyer shall impress upon his client compliance with the laws and the principles of fairness. 15.08. A lawyer who is engaged in another profession or occupation concurrently with the practice of law shall make clear to his client whether he is acting as a lawyer or in another capacity. Canon 16. A lawyer shall hold in trust all moneys and properties of his client that may come into his profession. 16.01. A lawyer shall account for all money or property collected or received for or from the client. 16.02. A lawyer shall keep the funds of each client separate and apart from his own and those of others kept by him. 16.03. A lawyer shall deliver the funds and property of his client when due or upon demand. However, he shall have a lien over the funds and may apply so much thereof as may be necessary to satisfy his lawful fees and disbursements, giving notice promptly thereafter to his client. He shall also have a lien to the same extent on all judgments and executions he has secured for his client as provided for in the rules of court. 16.04. A lawyer shall not borrow money from his client unless the client's interests are fully protected by the nature of the case or by independent advice. Neither shall a lawyer lend money to a client except when in the interest of justice he has to advance necessary expenses in a legal matter he is handling for the client. Canon 17. A lawyer owes fidelity to the cause of his client and he shall be mindful of the trust and confidence reposed in him. Canon 18. A lawyer shall serve his client with competence and diligence. Rule 18.01. A lawyer shall not undertake a legal service which he knows or should know that he is not qualified to render. However, he may render such service if, with the consent of his client, he can obtain as collaborating counsel a lawyer who is competent in the matter. 18.02. A lawyer shall not handle any legal matter without adequate preparation. 18.03. A lawyer shall not neglect a legal matter entrusted to him, and his negligence in connection therewith shall render him liable. 18.04. A lawyer shall keep the client informed of the status of his case and shall respond within a reasonable time to the client's request for information. Canon 19. A lawyer shall represent his client with zeal within the bounds of the law. Rule 19.01. A lawyer shall employ only fair and honest means to attain the lawful objectives of his client, and shall not present, participate in presenting, or threaten to present unfounded criminal charges to obtain an improper advantage in any case or proceeding. 19.02. A lawyer who has received information that his client has, in the course of their representation, perpetrated a fraud upon a person or tribunal, shall promptly call upon the client to rectify the same, in failing which he shall terminate the relationship with such client in accordance with the rules of court. 19.03. A lawyer shall not allow his client to dictate the procedure in handling the case. Canon 20. A lawyer shall charge only fair and reasonable fees. Rule 20.01. A lawyer shall be guided by the following factors in determining his fees. A. The time spent and the extent of the service rendered are required. B. The novelty and difficulty of the questions involved. C. The importance of the subject matter. D. The skill demanded. E. The probability of losing other employment as a result of acceptance of the preferred case. F. The customary charges for similar services, and the schedule of fees of the IBP chapter to which he belongs. G. The amount involved in the controversy and the benefits resulting to the client from the service. H. The contingency or certainty of compensation. I. The character of the employment, whether occasional or established. And J. The professional standing of the lawyer. 20.02. A lawyer shall, in case of referral, with the consent of the client, be entitled to a division of fees in proportion to the work performed and responsibility assumed. 20.03. A lawyer shall not, without the full knowledge and consent of the client, accept any fee, reward, costs, commission, interest, rebate, or forwarding allowance or other compensation whatsoever related to his professional employment for anyone other than the client. 20.04. A lawyer shall avoid controversies with clients concerning his compensation and shall resort to judicial action only to prevent imposition, injustice, or fraud. Canon 21. A lawyer shall preserve the confidence and secrets of his client even after the attorney-client relation is terminated. Rule 21.01. A lawyer shall not reveal the confidences or secrets of his client except A. When authorized by the client after acquainting him of the consequences of the disclosure. B. When required by law. C. When necessary to collect his fees or to defend himself, his employees or associates, or by judicial action. 21.02. A lawyer shall not, to the disadvantage of his client, use information acquired in the course of employment, nor shall he use the same to his own advantage or that of a third person, unless the client with full knowledge of the circumstances consents thereto. 21.03. A lawyer shall not, without the written consent of his client, give information from his files to an outside agency seeking such information for auditing, statistical, bookkeeping, accounting, data processing, or any similar purpose. 21.04. A lawyer may disclose the affairs of a client of the firm to partners or associates thereof unless prohibited by the client. 21.05. A lawyer shall adopt such measures as may be required to prevent those whose services are utilized by him from disclosing or using confidences or secrets of the clients. 21.06. A lawyer shall avoid indiscreet conversation about a client's affairs, even with members of his family. 21.07. A lawyer shall not reveal that he has been consulted about a particular case except to avoid possible conflict of interest. Canon 22. A lawyer shall withdraw his services only for good cause and upon notice appropriate in the circumstances. Rule 22.01. A lawyer may withdraw his services in any of the following case. A. When the client pursues an illegal or immoral course of conduct in connection with the matter he is handling. B. When the client insists that the lawyer pursue conduct violative of these canons and rules. C. When his inability to work with co-counsel will not promote the best interests of the client. D. When the mental or physical condition of the lawyer renders it difficult for him to carry out the employment effectively. E. when the client deliberately fails to pay the fees for the services or fails to comply with the retainer agreement. F. When the lawyer is elected or appointed to public office. And G. Other similar cases. 22.02. A lawyer who withdraws or is discharged shall, subject to a retainer lien, immediately turn over all papers and property to which the client is entitled, and shall cooperative with his successor in the orderly transfer of the matter, including all information necessary for the proper handling of the matter.